A man has been indicted on charges of sexual assault in Australia, a charge he fervently denies. The police initiated the legal proceedings against him following a complaint from his housemate, alleging that he violated her daughter. The question arises, what forms of proof can be used in Australia to substantiate claims of innocence in such cases? Legal cases are complex, and they can be influenced by a wide range of factors. Here are several types of evidence that might be considered in a sexual assault case in Australia. Physical evidence – this might include DNA, photographs, or medical reports. For example, DNA samples from the alleged crime scene that do not match the accused could be used to support their claim of innocence. Witness testimony – statements from individuals who were present at the time of the alleged crime can be very influential. If these witnesses can credibly state that the accused was not present during the time of the alleged crime, this could support the accused's claim of innocence. Alibi – an alibi provides evidence that the accused was elsewhere when the alleged crime was committed. This might involve witness testimony, video footage, or electronic data, like a timestamped email or social media post. Character evidence – evidence about the defendant's character can sometimes be used, though it is generally not enough on its own to prove innocence. In some cases, however, evidence that the accused has a history of nonviolent behavior or a lack of prior convictions may be considered. Inconsistent statements by the accuser – if the alleged victim or other key witnesses have made statements that contradict each other or the evidence, this could raise reasonable doubt about the accused's guilt. Expert testimony – experts can provide insights on physical evidence, mental health evaluations, or other relevant topics. Surveillance footage or digital evidence – surveillance video, mobile phone tracking, computer records, and other forms of digital evidence could potentially establish where the accused was at the time of the incident. However, remember that innocence isn't typically something that needs to be proven in many legal systems, including Australia's. Instead, the burden of proof generally lies with the prosecution, which must prove the defendant's guilt beyond a reasonable doubt. In legal terms, the burden of proof refers to the duty of one party in a trial to convince the judge or jury of certain facts or propositions. This responsibility typically lies with the party who initiates the case, the prosecutor in a criminal case or the plaintiff in a civil case. The burden of proof dictates who has to prove what and to what extent. In a criminal case such as a sexual assault charge in Australia, the burden of proof lies with the prosecution. This means that the prosecutor must prove, beyond a reasonable doubt, that the defendant committed the crime. Beyond a reasonable doubt is the highest standard of proof in most legal systems, including Australia's. It means that there can be no reasonable doubt in the mind of a reasonable person that the defendant is guilty. If such doubt exists, then the defendant must be acquitted. The accused does not have to prove their innocence. Instead, their defense team can attempt to introduce doubt by questioning the evidence or the manner in which it was collected, challenging the credibility of witnesses, or presenting alternative theories that are consistent with the defendant's innocence. Remember, this information is for general guidance and may not apply in all situations. Laws vary by jurisdiction, and the specific facts of a case can greatly influence the legal process. Always seek legal advice from a licensed professional when dealing with legal matters. This means that the defendant's goal is not necessarily to prove their innocence, but rather to raise reasonable doubt about their guilt. They can do this by questioning the prosecution's evidence, providing counter-evidence, or demonstrating that the police or prosecutors made significant errors in their investigation or case. Raising reasonable doubt in a legal case involves presenting evidence or arguments that create uncertainty about the prosecution's version of events. The idea is to leave the jury questioning whether the prosecution has truly proven their case beyond a reasonable doubt. Here are some strategies a defense team might use. Challenging evidence – the defense can question the reliability or validity of the prosecution's evidence. This could involve arguing that the evidence was improperly collected, mishandled, or misinterpreted. Presenting contradictory evidence – if there is evidence that contradicts the prosecution's version of events, presenting this to the court can raise reasonable doubt. This might include physical evidence, witness testimony, or alibi evidence. Questioning witness credibility – if a witness's reliability can be questioned, perhaps they've made inconsistent statements, or they have a reason to lie, this can create doubt about their testimony. Highlighting lack of evidence – pointing out that there is no physical evidence or no corroborating witnesses can raise doubt about the prosecution's claims. Presenting an alternate theory – if the defense can present a plausible alternative explanation for the evidence, this can raise reasonable doubt about the prosecution's theory. Undermining forensic evidence – questioning the methods, accuracy, or interpretations of forensic evidence can create reasonable doubt. Expert witnesses can often help with this. It's important to note that these strategies should be guided by an experienced defense attorney who is familiar with the rules of the court and the specifics of the case. Also, it's critical to remember that the goal is not necessarily to prove the defendant's innocence, but to question whether the prosecution has adequately proven their guilt. If the jury has reasonable doubts, they should acquit the defendant. In a situation where there's suspicion that an accusation is not genuine, but instead borrowed or copied from previous allegations against the defendant, a legal professional might approach it in the following ways. Inconsistent statements. If the victim has made statements that are inconsistent with each other or the known facts of the case, these could be highlighted to cast doubt on the credibility of the allegations. Prior false allegations. If the victim has a history of making false allegations, this could potentially be brought to the court's attention to question their credibility. However, this is a sensitive area of law and the admissibility of such evidence varies based on jurisdiction and specific circumstances. Comparison to previous cases. If the allegations are nearly identical to another person's story, especially if it was a high-profile case or widely publicized, a lawyer could present this evidence to argue that the accuser may have copied the details. This is a complex argument that would likely require expert testimony or other substantial evidence. Expert witnesses, psychologists or other experts might be able to testify about the likelihood of someone fabricating an assault story based on a third-party account. Character witnesses, witnesses who can speak to the character of the accused may help in casting doubt on the allegations, although their usefulness will depend on various factors, including their relationship with the accused. Digital evidence, emails, text messages, social media posts, or other forms of communication might contain evidence that the accuser was researching or discussing the previous case. Cross-examination. The accuser can be cross-examined during the trial, and inconsistencies or uncertainties in their story can be highlighted. Given the sensitive and complex nature of such cases, a legal professional should be consulted. They can offer specific advice based on the unique circumstances of the case and the relevant jurisdiction's laws. This is crucial as every jurisdiction has its own laws regarding what evidence is admissible and how it should be presented. Sexual assault laws in Australia vary from state to state. Each state and territory has its own specific legislation governing sexual offences, but all jurisdictions consider sexual assault to be a serious crime. Here are the acts that govern sexual offences in each jurisdiction as of my knowledge cut off in September 2021. 1. New South Wales, Crimes Act 1900, New South Wales, specifically Part 3, Division 10. 2. Victoria, Crimes Act 1958, Victoria, specifically Part 1, Division 2. 3. Queensland, Criminal Code Act 1899, Queensland, specifically Chapter 32. 4. Western Australia, Criminal Code Act Compilation Act 1913, WA, specifically Chapter 31. 5. South Australia, Criminal Law Consolidation Act 1935, SA, specifically Part 3. 6. Tasmania, Criminal Code Act 1924, TAS, specifically Division 4. 7. Australian Capital Territory, Crimes Act 1900, ACT, specifically Part 3. 8. Northern Territory, Criminal Code Act 1983, NT, specifically Chapter 23. These acts all cover a range of sexual offences and describe various circumstances, punishments, and defences. It's crucial to consult with a legal professional who is familiar with the specific laws in the relevant jurisdiction to understand the full legal context.